Thanks very much for joining us. This is our second podcast, the second John and Alan podcast. And since we first met, we've had, and I think we should admit to our listeners, our very many listeners, that we pre-recorded the last podcast in the expectation of a Labour landslide. And that duly happened. I even made a prediction that reform would do very well, and that happened as well. But now we have a King's Speech, and we have a Labour government with a stonking majority, and they've got lots of exciting proposals for employment law reform. Alan?
Yeah, John, we did pre-record it and we predicted as expected, and we've now got the King's Speech. We've got a smattering of the sort of things that will be in the new employment bill, although we are looking for some detail, and we can touch on that later. We're short on detail. I'd like to look firstly, John, if we could, at the unfair dismissal from day one right, which is one of the big headlines. I've come up with an idea which could make that work. I've not seen it discussed anywhere, but I wonder what you think about this.
Go on.
Perhaps we could have a limit on the amount of compensatory award that were to be awarded if somebody were dismissed, say, in the first 6 months. Perhaps limit that to, say, 3 months of losses at maximum, or a particular figure. It could be one way of appeasing employers in sort of getting this through. What do you think about that?
I'm not saying this to flatter you. I think that's one of the best employment law reforms I've heard in a long while. And is it potentially age discrimination? Probably not. Look, I think that's a very good idea, and I think one of the disappointments I had in the King's Speech is that there's a lot of aspirational change in relation to employment law, but there's no real detail. And so I was perhaps naively thinking that there might be an employment law bill proposed by Keir Starmer's government, but actually there isn't that. I think why your idea is such a good one is the government is clearly proposing to consult, perhaps in the second half of this year, as to what it intends employment law changes to be, probably into 2025 and beyond. And therefore, your idea, you should definitely put it forward as part of the consultation, Alan. I think it should be picked up.
I think it could work, and grateful that you recognise that as a good one. It just came to me and I thought, why doesn't this work? We have a limit already. We could just have a different limit depending on length of service, and it might be useful. We don't know. But as you say, we're short on detail, particularly on things like the extension of equal pay rights, John. At the moment, we have equal pay for differences in gender, and we've had that since 1970. It's a long, long time. They're now looking to introduce equal pay for differences in race and differences in terms of abilities and disabilities, but we've no idea how that's going to play out. We already have a very complex situation dealing with gender pay differences alone, and cases can run on for 3 or 4 years or even longer. You have to bring in specialist experts, of which there are not many, to speak on the subject and help the tribunal. So what do you think about that proposal, John?
I think it's very interesting. I mean, no one's going to be, I suspect, marching in the streets about this. And, I think that it is one kind of devil in the detail point, but they are probably the most complex cases in all of employment law, aren't they? Equal pay cases, because employers have to prove a negative, rightly so, if the employee is able to claim that this may be an equal pay issue. But for example, and I think it will result in mass claims or mass litigation if this is brought in. If a cohort of ethnic minority workers working in, for example, a supermarket, because a lot of these cases are in the retail sector. So at the moment, these are cases brought by women, and fair enough. They've won significant claims against Birmingham City Council. Birmingham City Council almost bankrupted as a result of an equal pay case, and that alone. But if a cohort of ethnic minority workers working for a big supermarket were to say, well, we think that we are underpaid compared to our white comparators, for example, we'd like to bring an equal pay case on that basis, that might be a viable claim if this proposal comes into effect. But it would be a fiendishly complex claim for employers to have to defend.
I agree. Very, very, very difficult claim. And if it succeeded, as we've seen with Birmingham City Council, as you said, the consequences can be drastic, bankruptcy. And if that was a normal private business, it would have gone bankrupt and would have ceased to exist. But of course, we can't let councils cease to exist, so it has to struggle along with little finances in a bad state. So yeah, one of the things that's interesting, John, is the strengthening of union rights. Not a lot of people remember this or even know this, but you'd think that unfair dismissal was a right that was brought in by a Conservative government, a Labour government, but it was in fact brought in by a Conservative government. And the reason it was brought in was to stop all the wildcat strikes. So rather than union members coming out in support of individuals, let's give those individuals some rights of their own that they can enforce, and hopefully that'll stop the unions calling all-out strikes. So, but interestingly, whilst they want to strengthen the unfair dismissal rights, this current Labour government, they're also strengthening the union rights. And I find that a very interesting dichotomy. What do you think?
I think that's right. I mean, I'm not an expert on union law, I have to say. I think that the proposals, which they're always going to do about the balloting procedures, because the previous government brought in changes to the balloting procedures about how you call for strikes. I think a Labour government, which is more than partly funded by the union movement, we're always going to row back from that. So I think it's going to be interesting to see whether they just change the internal workings of the union balloting arrangements, or whether there are broader, more substantive rights for unionised workers, which might affect a greater number of employers. For example, and you're more expert than I am on this, union recognition rights. We're seeing in relation to, companies that don't have unions at the moment, Amazon or whatever, facing union recognition cases. Are they going to allow big privately owned employers who at present don't have a unionised workforce, are they going to encourage or facilitate a unionised workforce in those big private employers? I think that will be an interesting one to watch.
It will be interesting, but as you say, we have no detail from the King's Speech yet, so we'll have to wait and see. And bearing in mind that Labour promised that these reforms, or certainly some of them, were going to come into force within 100 days of them being elected, we need to see some action on the detail pretty soon, I think, so that it allows for a reasonable amount of consultation with businesses and with trade unions.
And
one other area I want to look at, John, is sorry, you carry on.
Yeah, I agree with that. And just look,
Fun.
the reason why I think that they will do something on employment law is because the country is basically brassic. Rachel Reeves has said that, and therefore they've got to do the changes that don't cost a lot of money to be seen to be doing something. Yes, some of these changes are necessary. All of us would say that the 2-year qualifying limit for unfair dismissal is too long. The question is, what's the right period? But I think they will make changes in relation to employment law because on the face of it, it won't cost that much money, and it will demonstrate to Keir Starmer and the unions his left-wing credentials. So I think some of these changes will come into effect sometime in the next 6 months.
And you're right, John. On the face of it, it won't cost much money. But when it comes to implementation of people's rights, enforcement of people's rights, which is going to be done in the tribunal system, as we know, it's currently under the cosh in terms of keeping up with the number of cases. If we see a vast increase in the number of claims, then unless resources are pumped into the tribunal system, it simply won't cope. And I think that has just been disregarded in these proposals.
And so if I can match your one recommendation with one of my own, I was working out in the garden the other night, and I thought what one employment law change would make the most difference to employment law in this country. And I just thought a guaranteed right to an employment tribunal hearing within 3 months. If you could put that into statute and say you as a worker or you as an employee have a guaranteed right to a hearing within 3 months, it would revolutionize working fairness in this country, because you and I both know that employers play the game, sometimes cynically, because they know that if they if I unfairly dismiss you, or more likely the other way around, then one of us has to wait 15, sometimes 18 months for a hearing, and there's no immediate pressure on the employer to do the right thing. If the employer thought, hang on, if I treat this person unfairly or I discriminate against them, I could be sitting opposite them in a contested hearing within 3 months. I think that would revolutionize the employment tribunal system. But to do that, as you know, they would have to massively increase the expenditure and investment in the employment tribunal system, and the money just ain't there.
Yeah, do you know what? That's a really good point. Really interesting renovation to the system that would be. And in fact, if we go back to when industrial tribunals were first created, you used to get hearings after
Yes.
about 3 months. That's how it used to work.
That's how it used to work.
And one area of law that you do practice in quite a lot, John, where we do have these short timescales, is high court injunctions, for example. If an injunction is applied for, then there's a very, very quick hearing, and you know how much pressure there is there. Now, you're not talking about that level of pressure, but if I'm sitting here as an employer thinking, well, if I treat this person the wrong way, I could have to sit before a judge, an employment judge, in 12 weeks' time and explain myself. And how am I going to do that? So, yeah, I do like that. It's a really good idea, John. Maybe that's one you can put forward in the consultation.
I'll put forward that one. Okay.
Well, I won't claim that one. That's definitely yours.
Okay. 1-1.
As I was going to talk about, 1-1. I was going to talk about 0 hours contracts. As we know, large-scale industries use 0 hour contracts extensively to cover flexibility and the ebb and flow of work requirements. What's going to happen if there's a complete ban on 0 hour contracts, John? How are businesses going to operate?
Yeah, I don't know is the short answer. It's interesting that the day or two after the Labour landslide, I was listening to Radio 4 and they were talking about these proposals, and they were talking about the planning reforms being the first proposal. This is the second one, because for the reasons that we stated, there's no money and therefore they've got to do something. And they had someone on from a large employer saying, of all the things that you shouldn't do, you shouldn't ban 0 hours contracts because we have more flexible contracts in this country than any other country in Europe. We're better at getting first-time workers into work in this country than any other country in Europe. And as a result, it lends itself to a degree of flexibility and a facilitation of work that doesn't really exist anywhere else. So I think that this is the single biggest, thorniest issue that the Labour Party has to resolve. And I think it'll be really interesting to see how they do this, because the result is in the last 10 or 15 years, largely as a result of, if it's shown up, this facilitates your ability to work whenever you want, wherever you want. And the fact that you can be summoned effectively by your employer to attend a shift at, virtually no notice through an app has resulted in, flexibility for the workers and the employer, massive flexibility and cost savings for consumers that, it's an on-demand culture, but a greater interference, I think, in terms of workers' lives. So how they resolve that tension between choice and employment rights facilitated by technology, I think is the single biggest thing the Labour Party have to do. What do you think?
I agree, and I look forward with real interest to the consultation process about that. I'd like to see some of the views that are put forward from the unions and from employers, because I think it's going to be a really interesting sort of middle ground there. One other thing I want to talk about, John, is the things that we're missing from the King's speech. I didn't see anything about worker status, this employee, worker, stroke self-employed, the three categories. I saw nothing on that. And there was nothing at all about the right to switch off. If you remember, they talked about we have this right to switch off. When you're not working, you can't become. Didn't see anything mentioned at all in King's speech. Now, whether that's going to be in detail or in the bill when it's brought out, I don't know, but it wasn't mentioned. So any thoughts about those?
Well, I think that might be a sense of a dawning realisation by Starmer and Reeves that what they proposed is already extremely ambitious, and you've highlighted a number of those changes. But if they tried to do everything, it would, I think you think that the system would just gum up. So we talked in our first podcast ago about the risk of potentially giving all agency workers unfair dismissal rights if they eliminated the difference between a worker status and employee status. Perhaps they rode back from that. I would think myself that's a sensible thing to do, because I think agency work broadly is facilitative to the UK labour market. So maybe that's a dawning recognition that they've bitten off just about as much as they can chew, but if they bite off any more, they won't be able to do it. So I think the real thing moving forward in the months to come is going to be the consultation process, and what the iterative consequences of that is going to be.
Yeah.
What's your last thought in
Yeah.
terms of the proposals that they might have trailed last week?
I think my last thought is that I think they've thought again. I think they've had opinion, maybe from civil servants, maybe from lawyers in the civil service, saying, how are we going to make this work? You're trying to push too much through. Everything sounds good as a soundbite, but if you look at the practicalities, you look at what happens in day-to-day business, some of these proposals are perhaps unworkable, and they're coming to realise that now. Those are my thoughts and my feeling on the subject. So I think, John, we can wrap it up there now. I think we've really touched on as much as we can. There's little detail. We're having to speculate on these things. Maybe we'll see more in the consultation when it comes out in due course.
Yeah, and we've got to encourage our employer clients and also any individuals listening to this to feed into, if they want to, the consultation process, haven't they? Because there's a lot of interesting, good ideas. They're talking about flexible working rights from day one, for example, an extension of maternity rights. So there is a genuine desire to move to a more family-friendly, flexible, perhaps pro-Scandinavian way of living as a country. But that requires careful thought and consultation, because it's not just employment law here. If you give more flexible working, you're going to have to spend more money in relation to childcare and creches and things like this. So everything is going to have to be joined up. You can't just treat employment law in isolation. You're going to have to deal with it in a holistic way. And I think it's going to be really interesting that we've got a new government now. We've got a new set of ideas. We've got a new a bunch of people in charge to see how they take forward some of these very many ambitious plans.
Yeah, that's it. Fantastic. Really enjoyed discussing that with you today, John. We'll do another podcast next month.
See you next month, Alan. Thanks a lot. Take care.
See you then. Thank you. Bye.